Hello and welcome. I am Chakshu Roy and you're watching Laws in the Making on Rajya Sabha TV. Today on the show, we are discussing the Draft Employee Provident Fund and Miscellaneous Provisions Amendment Bill 2019. To discuss the amendment bill, I have on the show with me Mr. Subhomoy Bhattacharajee, Consulting Editor, The Business Standard, and Mr. R.K. Kukreja, former Additional Central Provident Fund Commissioner, Employees Provident Fund Organization. The draft EPF and Miscellaneous Provisions Amendment Bill 2019 proposes to change the Act in accordance with the announcements made in the 2016 budget. It also seeks to amend the definition of wages in accordance with the Code on Wages Act passed in this year.
The Employees Provident Funds and Miscellaneous Provisions Act 1952 is applicable to every establishment in India with 20 workers or more. Provident Fund is similar to a pension fund in that they are both retirement savings funds meant to provide financial support to retirees. Employees make fixed contributions from their salaries each month with a matching contribution made by the employers, and a lump sum payment is made to the employee when they turn 60.
Basically, what is the present situation with respect to EPF Act is the most important, if I would say in one line, the most important issue is with regard to the compliances. And compliances and non-payment of contribution collected by the respective employers. So, this is the present situation, and that is why various other litigation, various other penalty actions which are being taken by the respective EPF department and the government also. So, the basics, the most important problem is with regard to the compliances. People are not complying in time properly, and they collect contribution on behalf of employees as well as their behalf, but they don't pay on regular intervals, on regular frequency, which is being prescribed by the Act.
The draft bill specifies that the employer and employee contribution will be 12%. The bill proposes to change the definition of wages based on which the EPF contribution is determined. The bill changes the definition of wages to include basic pay, dearness allowance, and retaining allowance. The amendment will replace the existing definition of basic wage. Further, the bill adds the stipulation that if the total amount of payments not included within the wage exceeds 50% of all remuneration made by the employer, it will be included in the wages.
The penalty amount has been increased by 10 times, means earlier the penalty which was 5,000, now in the proposed amendment it is 50,000, and 25,000 has been increased to 2,50,000. One more amendment is being brought in the Act which is proposed now, that is, which was not earlier in the section 14 of the penalties. That is, the whatever violation was being done, it was not a compoundable thing. Now compounding is being done in the proposed amendments, meaning by wherever in certain cases a provision is being made that the matter will not go to the civil court, but a penalty will be imposed, and by payment of that penalty, that prosecution will not be done.
The 2016 budget announced two key changes with respect to the Employees Provident Fund. First, contribution to the Employee Provident Fund should be made optional for employees earning below a certain threshold without reducing the employer's contribution. And second, existing members of EPF should be allowed to switch to National Pension Scheme, which is a voluntary contribution retirement savings fund regulated separately by PFRDA or Pension Fund Regulatory and Development Authority.
The Employee Provident Fund is an important mechanism for employees to save, for their future. Subhomoy, I wanted to start the program with you and just ask you about the genesis about how the EPF originated in India, after independence.
The EPF?
The EPFO is basically, in fact, it came up after several organizations like the coal miners and others had set up their own provident fund organizations, and the EPF sort of took up all those and created the Employees Provident Fund in the 1950s. It basically, the idea was that as India was going to industrialize, there would be large number of workers in the manufacturing sector. They would be needing a provident fund support to help them in their future, in their post-retirement years, since the government wasn't going to be able to give them a pension support. So basically, there should be a sort of a organization, a sort of a tripartite organization headed that way, to ensure that their money was invested safely, well, and definitely with ensuring that the money is there. There's always, after all, if it was voluntary, then there was always a possibility that people wouldn't be paying up.
Correct.
So here was the organization that was set up to ensure that this organization would definitely have a sort of a coercive ability to ensure that people do pay up, the companies do pay up and invest there, and the company, and then the money would be invested as per the guidelines of the Central Board
a
of Trustees.
coercive ability and a fiduciary responsibility then to ensure that people had access to that money post-retirement.
Post-retirement.
Mr. Kukreja, you've been part of this organization for the last 30 plus years. When you look at EPF, what are the things that stand out for you, and, what has been the evolution of EPF in India?
As my friend has said, the Employees Provident Fund organization was set up in the year 1952 with the promulgation of the ordinance, and thereafter the act was passed by the Parliament. The act at the beginning specified 6 industries on which the act was applicable. The act was basically made as a contributory provident fund scheme, contribution from the employee and contribution from the employer. Later on, with the passage of time, the number of industries were more and more number of industries were included in the schedule of industries, as well as there were a clause of establishments are also included in the provisions of the law. The act is applicable on the establishments employing more than 19 employees, and their activity is in the schedule of industries or in the classes of establishments. With the passage of time and growth of the EPFO, Employees Provident Fund scheme was there in 1952. Thereafter, family pension scheme was also introduced in the 1971.
Okay.
In the family pension scheme, the family members of the employees who will die during the course of their service will be entitled for the pension. This was a meager pension. Thereafter, employees deposit link insurance was introduced in the year 1976. In this scheme, basically the assurance benefit was given to the family members of the deceased employee. Presently, the minimum amount which is being given in this EDLI scheme is 2.5 lakhs and maximum amount is 6 lakhs. This amount is linked with the deposits in the Provident Fund account.
Correct.
Thereafter, in 1995, the Employees Pension Scheme was introduced. This Employees Pension Scheme 1995 took over the employees corpus of the Employees Family Pension Scheme also.
Correct. Okay. Subhomoy, so, Mr. Kukreja was talking about how EPF has evolved over the years. If you wanted to explain to our viewers, what is the rough mechanism? How does EPF work? There is obviously a coverage of organizations, but what do people do?
Yeah, basically what it does is what any financial organization does. A bank takes in deposits from people and lends it out to those who want to do business and earns interest. And similarly, an employees provident fund takes money from the employees and the employers, parks that money in different lines of assets and earns returns and based on those returns, it gives interest to the workers. That's the nub of what the EPF does. Within that, of course, there are lots of other things. It sort of acts as a sort of a good faith organization, because a lot of workers' security and safety is got to do with the fact that whether the fellow is getting salary, whether the salary is properly being credited, the safety net that the government of any country would expect to provide for the workers in terms of crisis, that is being ensured by EPF. So there are lots of other, what you might call, related benefits that come along. Correct. The core basis, of course, is basically the fact that it takes the money and invests in lines of investment, and from there the money is paid out to the workers, either in lump sum, or in the case of pension fund, as Mr. Kukreja talked about, it's paid out over time.
Yeah. Okay, Mr. Kukreja, so we talked about the percentage of contribution that employers and employees have to make. What is the determination of this contribution? What is the basis for this contribution? Do you have to pay over your basic salary, over your allowances, or is there a definition which needs to be followed?
As per the provisions of the law, the contribution is to be paid on the basic wages, dearness allowance and retaining allowance, if any.
Yeah.
The establishments are paying the salary with different components. They are paying basic wages, they are paying dearness allowance, and in addition to their dearness allowance, they are also paying certain more allowances. The Act has defined as to what allowances are exempted from the Provident Fund, that is house rent allowance and other allowances, they are there. But the establishments, in their own mechanism of defining their salary, they defined certain other allowances also. Recently, the Honorable Supreme Court has given a decision as to what allowances has to be taken as a part of the basic wages.
Okay, so what you're saying is each of us gets a salary, not that entire salary is counted as wages on which contribution has to be paid either by us or by our employers as an EPF contribution.
Yes, the law has defined that the contribution is to be paid on basic wages and dearness allowance. There was some confusion in relation to the what allowances can be exempted and what allowances are not exempted. Recent decision of the Honorable Supreme Court has clarified this issue, although this clarification had been given earlier also, but they have reiterated it and it has been now clearly defined.
Okay, Subhomoy, one of the things that the Draft Act is doing is bringing the definition of wages in consonance with the Code of Wages Act. Can you talk a little bit about that?
Now that's where some of the problem starts coming along. Of course, what's happening is, at one level, it's fairly simple. The Code of Wages, which has been passed by the Parliament in the last session, says that there will be it sort of defines what is wages. That's very important, because there are different industries which actually define wages differently within the manufacturing sector itself, but even between manufacturing and services, there are definitional issues. This one sort of says that, if you are going to, because EPF, the idea is that there will be an expansion of the wages, of the role of EPF to different sectors. So there should be harmony on what should be constituting as wages.
Okay, perfect. And that cuts right into, when we can take a break. When we come back, we will discuss the provisions of the bill introduced in accordance with the 2016 budget and penalties prescribed in the amendment. Welcome back. On the program today, we are discussing the Draft Employee Provident Fund and Miscellaneous Provisions Amendment Bill 2019. The bill proposes to change the Act in accordance with the announcements made in the 2016 budget. It also seeks to amend the definition of wages in accordance with the Code on Wages Act 2019.
The draft bill makes contribution to the Employee Provident Fund optional for some employees. The bill seeks to introduce this flexibility into the Act based on factors such as age, income, and gender. The bill does not propose any changes to the employer's contribution.
One very important thing was that there was no limitation. So if anything is committed and if the department think that some employer has committed any mistake by calculating of these wages or not getting registration or not paying the interest, in fact, they were going for inspection. The case might have been 10 years, 15 years, 20 years old. So I suppose towards the ease of doing business, now under the new amendment, this problem has also been resolved. Now the limitation has been fixed for 5 years. So if there is any offence being committed by any employer, up to 5 years, any inspection can be done. And one very important positive move, I suppose, by the government is that this Employee Provident Fund for this EPF, a specialized circular has been issued.
As per the draft bill, Employees Provident Fund subscribers can exercise the option to switch to National Pension Scheme instead of availing benefits under the EPF Act. NPS refers to a voluntary contributory pension scheme regulated by the Pension Fund Regulatory and Development Authority. Further, the bill proposes that the NPS subscriber may opt to return to EPF at any time.
The government even have gone one more step further to bring in a social security code which would encompass many other social welfare schemes into that code for the benefit of public at large. So this is going to be a very important step in times to come, and I believe that this is going to change the face of the economy. The kind of security which is going to be provided to employees who are not into government, more specifically not into pensionable jobs. So this is going to enhance the security available to the workers, and resultantly the productivity, the efficiency is also going to be enhanced.
The draft bill imposes harsher penalties by increasing fines for all offences by tenfold. For instance, the fine has been increased from 5,000 rupees to 50,000 rupees for avoidance of payment. The fine for repeat offences is currently 25,000 rupees. The bill proposes to increase this to 2.5 lakh rupees.
Mr. Kukreja, one of the things that the draft amendment is doing is allowing certain section of employees not to make full contributions towards their EPF. Now, what is the rationale for that?
Rationale is there are certain sectors where the employees are getting a very low wages, and these employees can hardly afford to give their contribution to the Provident Fund. So this issue had been discussed on various forums earlier also, and it was desired that there should be some provision where a class of employees, those who are getting very low wages and cannot afford to pay their contribution, they should be given some kind of relief so that they make either less contribution or for a specific time period they do not make any contribution, and they can still be a member of the Provident Fund schemes because the employer's contribution is not being waived at all.
Okay, so as an employee, to ensure that I'm able to take enough of a salary home, my contribution can be either reduced, but my employer's contribution continues to remain the same so that my post-retirement nest egg, so to say, remains intact. Subhomoy, the other thing, that the draft amendment is doing, it's increasing the quantum of penalties and it's increasing them tenfold. Now, why is that happening?
Yeah, I mean, obviously, if you look at over the years, annual report of the EPF, and if you look at the number of companies which have defaulted, this includes exempted companies also. There's within EPF, there's a set of companies which run their own Provident Fund. They are guided by the Provident Fund EPF Act, but they run their own trust, they have their own trustee bodies. And there have been instances galore where companies whenever they are into liquidity problems, have held back on Provident Fund, whereas they're not supposed to because it's a statutory due.
Yeah.
Now, while the statutory due, the punishment wasn't particularly great, so therefore there was always an incentive to game the system. So therefore the punishment comes in, which is fair enough. I mean, if there's a law, then the law needs to be implemented. There's no particular reason why it should be, I mean, even people shouldn't be getting away with it.
Mr. Kukreja, the quantum of punishment?
Yes, I should say basically any penalties imposed for violation of the law. In the instant cases, earlier the penalty was revised in the year 1988. And in order to discourage the violation, the penalty has to be substantial so that the establishments follow the law.
It has to be, the penalty should be an amount which is deterrent, so
Deterrent.
that
It should be a deterrent.
It should bite.
It should bite, and it makes you consider that you need to follow the law. But when it comes to following the law, one of the other provisions is what happens when companies fail, right? And who gets, when it comes to debtors and creditors, who gets the money first when a company fails? And Mr. Kukreja, one of the draft amendments is relating to that cascading flow of funds when a company is declared insolvent or the companies fail. What is that about?
The present law also says that there is a priority of PF dues over the other debts in case of insolvency of any establishment. In fact, the Act mentioned about Insolvency Act of 1909 and 1920, and these two acts have been repealed by the Insolvency and Bankruptcy Code, which has been recently introduced. So there was a requirement to reintroduce this section by saying that notwithstanding anything contained in any other law, the Provident Fund dues will have the first priority over the other debts in case of insolvency of the establishment.
Okay, but if I had to ask you, what is the priority in which an insolvent company has to pay out? So is the Provident Fund
It
dues
is the first priority.
Okay, and everything else, taxes owed to the government,
Everything next.
everything else comes second. Okay, that's great. Subhomoy, one of the things that I ask, all our panelists is what is going to be the impact of a legislation or a proposed legislation like this on, let's say, the Provident Fund employees, the people who contribute to the Provident Fund, and also to the organizations, who are part of the Provident Fund?
Yeah, that's a good question, because what will be the impact? One of the reasons why this act was done was basically, as you talked about, the code on wages is coming along, and the idea is that the benefits of the EPF should actually be going to more classes of employees, except so that is the reason why these laws have been tightened up, streamlined, tweaked to ensure that they are more flexible and they address the needs of the new economy. So definitely it does make it easier. It makes it more difficult for units to stay away, those who are supposed to be part of the EPF. That's a great step. I mean, employees need to feel that whenever there's a particular level at which the company is operating, then the company should be playing up, taking care of its workers. So that's a major thing. In terms of and the fact that the penalties have been higher and the exceptions have been tightened is essentially ensures the same thing, that it becomes very difficult and it becomes very easy for somebody to monitor and to ensure that the company's units are forced to be part of the EPF package. So yes, to that extent it becomes more omnibus.
Okay.
There's been a lot of, globally also there's a lot of this concept of social security totalization agreement that we have with countries, and often one of the reasons why Indian workers, for instance, when they go abroad, they have to pay an extra social security net is because our social security net is often not considered universal. The movement in the EPF Act actually moves it towards universalization. Okay. So to that extent, there's definitely a benefit.
Okay, Mr. Kukreja, one of the final things that the draft amendment is doing is allowing for an option for people to switch to the national pension scheme. Can you elaborate on that?
Yes. When the employees' pension scheme was framed and announced, it was with the concept that we are going to give benefit of the pension to the member himself on attaining the age of 60 years, 58 years. And in the event of his death, the pension will be given to his family members. Family members, we covered the spouse as well as 2 children, those who are below the age of 21 years. And the dependent parents have also been included in the pension scheme. At that point of time, the pension scheme was framed with the thought that we are giving this pension scheme to the low income employees. The salary wages limit at that point of time was 6,500. Thereafter, the government decided to increase the wages limit to 15,000 in September 2014. And 1st September 2014, the government issued a notification where they specified that those who are drawing wages more than 15,000, they will have to bear the pension contribution which was being given by the central government, that is 1/6% of the wages by the employee himself. This notification has been quashed by the Honorable High Court of Kerala. EPFO made an SLP in the Supreme Court. The Supreme Court has not gone into the merits, but they have disallowed the SLP.
Okay.
With this disallowing of the SLP, the Employees Provident Fund organization has to make the pension to the employees, those who are drawing more than 15,000 also.
Okay.
The EPFO is of the opinion that their corpus is not of that nature and they will not be able to carry on with this pension payments. In fact, in the, as you have also mentioned, in the 2015-16 budget also, there was a provision for the allowing the
Correct.
Employees to switch over to the national pension system. So with that in mind, now they are bringing a provision for option for national pension system.
So the idea is to let people decide as to which side they want to switch on. Subhomoy, close the program with us with your final comments on what the draft act is doing.
Well, it's a good act. I mean, basically what I sense is, and I hope that is what is going to be, that it's basically going to make the provident fund sector in India more flexible. You know, people should have the right to decide how and what sort of a provident fund they will go. That they will have to pay, and they will have to take a long-term security, that goes without saying. And that is what the Provident Fund Act is doing. At the same time, if it's bringing in NPS, hopefully it will be able to bring in more players into the system and give the flexibility and make EPF as part of one. You know, that is what I suppose is the ultimate aim. And to that extent, I would say yes, I mean, make a sector agnostic, I mean, a sector based system rather than a company based system. And to that extent, it's happening, and it's probably a move in that direction. Wonderful.
Okay, great. Thank you, Mr. Kukreja, and thank you, Subhomoy. That's all the time that we have on the show with us. You can watch our shows on the RSTV page of YouTube. We will be back with a new issue and a new episode. Keep watching Rajya Sabha TV.
Thank you.